And good morning, good afternoon, or whatever time you happen to be tuning in to today's segment of The Power of Money. I'm your host, Michelle Graves, nationally and internationally known as the Money Lady. Why? Because I've been involved in the field of finance, banking, insurance for over 36 years. And it is my distinct pleasure and privilege today to bring back a guest that I had on not too long ago. But we simply got engaged in the interview and ran out of time. Can you believe that you can have such an amazing experience that you run out of time? So I invited her back and she agreed to come again to finish up what we left laying on the table. So I want you to sit down, get a piece of paper, call your friends, people you love, care about, and listen to Nancy Roberson, attorney at law, who specializes in estate planning, legacy planning, asset protection for seniors as well as everyone else, actually. But we're going to resume our conversation and try to cover some of the areas that we skipped over on our last interview. And you will find Nancy Roberson to be a delightful, delightful individual. And you will understand at the conclusion of this interview why she's not only special, but why she has been so successful. So, listen in, here we go. How are you?
I'm terrific.
I'm
And
glad
you?
to have you back.
Thank you. It's a
What
privilege.
a privilege to have you back, a woman of
Indeed.
such knowledge and such experience, and a woman that loves the Lord. That is so
Amen. Yes.
wonderful to hear and to be a part of. So where do we want to begin? Let's begin by reintroducing you to my viewers. If you could give me a little bit of your background, your area of expertise, and then we're going to get into the meat of what we missed on our last interview.
Very good. My specialty, I'm a certified specialist by the Ohio State Bar Association in the areas of estate planning, probate, and trust law, and have been since 2001 or 2, when the first class of our group was certified. I got in that class. And our firm is what is called a boutique firm. We limit our practice to those areas of planning for people, death and disability planning.
Interesting. And how long have you been doing this now?
Well, I've been at it over 25 years, closer to 30 years.
Then you've seen a lot.
I've seen a lot,
I
yes.
just know that you have.
Uh-huh.
So let's talk about the issue of wills and what is a comprehensive estate plan? What does that look like? And I ask this question because I've had many encounters as an advisor where I've had to look at the paperwork of your profession, legal persons, and argued with people about some of the incompleteness in the documents that they presented to me. Would you care to speak to those
I
things?
would love to speak to those things because in addition to this wonderful opportunity that you've given me today, I do a lot of public speaking for civic groups and professional groups and church groups, and it's not uncommon. I've called myself Naive Nancy over the years. Never did that speaking to generate business.
Yes.
I did it because I have a passion to educate people. But people started calling after speaking engagements, and one lady called and scheduled an appointment, and then she called back and said, my husband doesn't want to meet because he says that he can download a will form from the internet and take care of our estate plan that way. And I said, well, I know
Okay.
that you realize from having heard my presentation that there's a lot more that goes into estate planning. And Michelle, what I mean by estate is everything that we own. You know, before I went to law school in 1978, my idea of an estate was this home-orama type home on a gorgeous countryside with a circular brick driveway and a Mercedes-Benz sitting there and horses grazing, you know, because I'm a farm girl. So that was my idea of an estate. And then I went to law school and I learned that an estate is everything that I own, my checking account, my investments, my insurance, my property, but also estate planning relates to issues with regard to decisions that may need to be made about my finances or my health. So just to give that little bit of background, I do estate planning, not just death planning or disability planning. And so in response to the lady who called and canceled the appointment because her husband could download a will off the internet, well, certainly a will was important, but it wasn't by far the only document that was needed. For our simple estate plans, our simplest estate plans that we do in our office, we do a will for, let's say it's a single person.
Okay.
We do a will, a single person with, who doesn't have a reason to do a trust, which I can talk about in a little bit. A will, a general durable power of attorney, health care directives, which at a minimum consist of a health care power of attorney. Sometimes, more than sometimes, most people get a living will as well. We do some additional health care directive documents, a HIPAA form, for example, because the Health Insurance Portability Act has invaded our lives, and we want to have a HIPAA form associated with the health care directives too. We also review, many people are interested in avoiding probate, and so we talk about that, about how their assets will avoid probate. Michelle, we send our clients a packet of information that includes a 21-page checklist to complete, and that can be pretty daunting.
I was going to say that can be a little challenging.
We've had some clients come in looking a little bleary-eyed for their morning appointment because they opened the packet at 10 o'clock the night before and discovered this monster that they needed to complete. And some of them don't even bother. They just come in and say, well, can I do it later? And yes, but you'll be, since we bill hourly for our services, you know, we don't want to have to bill people for playing secretary, you know.
Exactly.
So that's why we send the checklist. But we review how people own their assets and then make recommendations about avoiding probate if that's important to them. That checklist also contains a list of goals, and we ask the prospective clients to rank their goals in order of priority. And so we give advice based on the client's values and goals, what's most important to them, and do the documents accordingly.
Now, you had brought to my attention a document that I was not aware of that you include, which is the disposition of remains.
The right of disposition of remains. I forgot that. I'm sorry. That would be part. That would be part of the single person's estate plan too.
Now, I ran into a contentious situation with a very prominent attorney in my city, whose packet did not include that document, and the DNR, do not resuscitate document, was not there. The HIPAA was not there. And the client said to me, he said, those documents are trivial documents.
Oh my goodness.
And that's what he said to her, and here I was, I'm not an attorney, nor will I be involved in the unauthorized practice of law, which is a criminal offense. But I said to her, that is irresponsible, and those are critical documents. Now, why would he say something like that?
Michelle, I don't know, except perhaps he hasn't been involved, hands-on involved with the issues that can arise. Maybe he hasn't, like I have, served as fiduciary for people who, you know, I've had to make funeral and burial arrangements for people. And I don't remember if I talked about this during our last session, when a lady for whom I was responsible died. She died suddenly, and she had prearranged her cremation, and the funeral home insisted on getting the consent of her next of kin, and she had told me she had forbidden me to notify her one living son until after the funeral because they had a toxic relationship, and she didn't want him coming and disrupting the funeral. And so thankfully she had signed this right of disposition of remains form, and once the funeral home saw that, they saw that she had given me the authority to direct her cremation. That's been my experience with funeral homes in the Miami Valley, that because cremation is such a sensitive issue.
It is a sensitive issue.
Funeral homes want to protect themselves, and so they're going to request the consent of the next of kin unless a person has the right of disposition of remains, or rotor form as we call it for short, giving one person the authority to be in charge of the funeral and burial. But thank you for mentioning that, because I forgot to include it
Oh,
in the
that's
list.
quite
And we
all
always
right.
do. It's a form, and I do want to emphasize, we try to, we're frugal.
Yes.
We talked a little bit about being frugal before we
Yes,
started this
yes,
session.
yes.
We give our clients as many forms as we can to fill out on their own, and we don't charge them a document preparation fee if they fill those forms out on their own and then bring them back
Completed.
to completing, except for having signed them, and then we'll witness the
signature.
signature and put the notary on at that time. But the right of disposition is one of the forms that we routinely give people.
Can we talk about this do not resuscitate
Yes,
document
yes.
as well? Because I'll give you an actual case where an individual went in for surgery, a young woman, and did not know she had sleep apnea. Exactly. And she went under anesthesia, and they couldn't get her out.
Wow.
And that's how she, and literally she was rushed to the hospital. She went into a coma, and they were able at the hospital to bring her back. But she had none of those documents in place at all, because she had argued with me, well, I don't need that kind of stuff. And I was like, but you never know. Now, the question I have to ask you is, if they chose not to resuscitate her because of possibility of brain damage, and she did not have these instruments in place, if she had said, aggressively resuscitate me, would they have been obedient to that request, or would they have let her just go on into another world?
If the EMT professionals who arrived at her home had the documentation, then they are required to honor a DNR order, but not a living will or a healthcare power of attorney or a HIPAA form.
Okay.
The EMT professionals are required to honor only the do not resuscitate.
Okay.
So they have, it's my understanding, by law, they have to resuscitate unless they see a DNR order. That's my understanding of the law.
Okay.
Having a living will or a healthcare power of attorney would not have made a difference in
In her
that
case.
situation. Doesn't mean you shouldn't have had those documents. However, the law requires the EMT personnel to resuscitate,
Okay.
absent a DNR order.
Well, I will say this to those of you that are my viewers. If you have sleep apnea, and many of you may not know it, and many of you do know it, by all means, get your documents in order. I am so serious here. Get particularly your HIPAA, the documents that Nancy has referenced in our interview today. Her outcome could have been very serious.
It could have been very serious,
It,
yes.
it really, to go in for a procedure and to find yourself in a coma and facing death, because sleep and sleep apnea, your breathing ceases. And there is a completely different process, I've since learned, for people that have that condition.
Yes, and let me pick up on that, Michelle. I see two different issues here.
Okay.
One is the immediate decision-making that should or should not be done based on the person's wishes, but then the immediate healthcare decision-making.
Right.
But then the long-term financial decision-making, because if a person does not have her documents, any estate planning documents in place, doesn't have not only the healthcare directives that you just mentioned, but a general durable power of attorney, then long-term, if the person stays under the coma, there's not
Oh my
someone who can pay that person's bills for her,
Right.
do whatever needs to be done in the long term, renew the lease,
Right.
whatever needs to be done financially. And at that point, then someone has to go forward and ask the probate court to be appointed as her guardian in order to make personal and financial decisions for her. And nobody wants to go there with guardian. You just don't want to have to go there with a guardianship. They're expensive, they're time consuming, they can be demeaning, they can be contentious if more than one family member wants to serve as guardian, and frankly, the issue is often, well, the issue is control of the money, with not only because of control, but maybe I can get my finger in the pie somehow too. Terrible thing. There's a lot of mismanagement of people's money with powers of attorney as well. So you got to pick somebody who you choose. There was a probate judge years ago who stated at a conference seminar that I attended that 30% of the guardians mismanage their ward's money. And that was guardians under court authority. Even they did it when somebody was looking over their shoulders. So by all means, it's very important to choose in a power of attorney the first, second, and third choices of people of integrity and honesty and capability to handle personal and financial matters.
I like the fact that you said not just a primary, but a secondary and even a tertiary.
Yes.
And of integrity.
Yes.
And character.
Yes.
And then capability.
Yes.
Because they can have integrity, but not have capability.
Correct.
And that can create problems.
Yes, it can. The most well-intentioned person, if he or she doesn't have the ability, the financial acumen, to handle investments, for example, to even know, you know, Michelle, we don't know what we don't know, and to know with whom to consult.
I think that's so powerful, and I think a lot of people, particularly viewers, would ask, well, I don't know anybody like that. I know people that are of good character, maybe my pastor or my associates, but the issue of capability. So what are their alternatives?
Well, I've written a few powers of attorney where people have appointed the person who their financial advisor would appoint, or their pastor would appoint, or their lawyer would appoint, for example. My practice, some of my business also involves serving as fiduciary, as power of attorney for people who don't have anybody else. Now, we explore with our clients, we really try to find somebody, appropriate family. My definition of family are people I choose to belong to. So
I like that definition.
So they may not necessarily be blood relatives, but they may be closer than blood relatives and very capable.
Well, that's very interesting because, as I said, in her situation, if she had not come out of that coma, the consequences would have been devastating. And I don't know if she has remedied that, because that crisis is over. And it's been my experience that human beings are incredibly human.
We are.
Which is disassociative, which is don't bring it up, don't bring it up, don't bring it up. But it has to be brought up.
I heard years ago, heard or read, that psychologists know that when we hear motivational information like this broadcast, that we have about a 2-week window of opportunity. Like this broadcast or an incident, a health incident, about a 2-week window of opportunity, and then our motivation starts to wane.
That's interesting.
Yeah, so I always tell people, when you hear something you should do, start. You know, the prospect of doing all this can be very daunting. I'm not saying finishing it in 2 weeks, but get started. I used to have a flying phobia, I'm ashamed to say, but thank God the Lord has cured me of that. And for our 15th wedding anniversary, my husband put his foot down and said, we are going on a cruise to the Caribbean. And I couldn't see that we could drive to the Caribbean. So I really made a concerted effort to get everything in order and get the last T crossed and last I dotted, because I was sure the plane was going down. Boy, that's a woman of faith, isn't it? But anyway, obviously it didn't, and
Yeah,
I'm here
then
to,
you're here today.
You know, and that was part of the recovery process of the flying phobia, is doing it.
Right,
you know,
right.
just
And
doing,
facing your
facing it
fear.
and doing
Yeah,
it and doing it. But I'm a busy person. I work a lot. I thought, how am I going to get all this done? So I decided to allocate, it was either an hour or two, I don't remember, every Sunday afternoon. Now, for those of you who strictly observe the Sabbath, and that may not be appropriate to do if Sunday is your Sabbath, but for me, it was Sunday afternoon, and I faithfully worked on our estate plan for that allotment of time until I got it done, and I finished it right before we left. So I would say to those who are getting started, who need to do all of this, get started, call and schedule an appointment with a lawyer, because
No, not just a lawyer.
with me.
Well, not only just with you, but certainly with an attorney that specializes in this.
Yes.
Because I
yes.
shared with you a very prominent attorney in my city had holes in this estate plan.
Well, and that brings up another point, just to talk about lawyers. We lawyers, if we are licensed in Ohio, or if you're listening in Kentucky or Indiana, every lawyer who is licensed to write a will.
Okay.
Has the authority of the state to write a will. But that does not mean that the lawyer knows how to do estate planning. You know, we women generally, when we are expecting a baby, we go to an OBGYN to deliver our baby. And likewise, for estate planning, we should go to a lawyer who, if not a certified specialist, at least is held out in the community to be excellent in the area of estate planning.
Because the worst thing in the world, Nancy, to find out that it was done badly is when you have crossed over.
Indeed.
And you've left the mess
Yes.
to your heirs and your family.
Yes.
That is not the right time to
No,
find
it's-
out that things were not handled
No.
properly. That's just not good. So moving on, let's talk about overlooked areas in your practice when you run into areas that people really need to focus on. Let's start with a trust. What is a trust, and do you need one?
A trust is a written document that spells out how property will be managed and distributed, generally after a person dies, but also during that person's life as well. The most common type of trust is called a revocable living trust. The primary reasons why people get trusts are, first of all, to minimize estate taxes, secondly, to defer distributions to beneficiaries, and then third, to avoid probate. Now, I'm just licensed in Ohio, so I can only speak for Ohio citizens, but we don't have an Ohio estate tax anymore as of January 1st of this year. In the past, we'd written a lot of trusts to put married couples in a position where they could either minimize or eliminate the Ohio estate tax. But even so, if you're listening and you're a citizen of the United States, there is still a federal estate tax. The exclusion amount was set by the fiscal cliff legislation at $5 million and is alleged to be permanent.
Alleged.
Until the next time.
Until we find we're broker than broke.
But at least we don't have a sliding scale anymore like we did for
yes,
many years.
Yes,
Yeah,
it's just a flat $5 million.
It's a flat $5 million indexed for inflation. So
okay.
Actually this year it's either 1.125 or 1.25, but I don't remember what the inflation factor is. And it will go up. Inflation will be taken into account over the years for that. So there are wealthy people if a married couple's combined net worth is over $5 million, they ought to get a trust to minimize the federal estate taxes, unless they're giving everything to charity. They may still want a trust to avoid probate, but there is a dollar per dollar charitable deduction. So if they give everything to charity, which is a good thing,
I think
generally,
so. I think that's very American.
And in fact, I would like to say as an aside, I think more people ought to be giving to charity than they are, that we ought to include at least a 10% gift of our estate to charity.
I agree.
And
I couldn't agree more.
So I just wanted to
Well,
throw
thank
in
you for
that
that.
plug for charitable organizations and that sort of thing. So although a person may not need a trust to minimize federal estate taxes or the state taxes wherever you live, they may need a trust to defer distributions to beneficiaries. For example, I use this illustration. My daughter is 38 now, and she's very responsible
Yes,
financially.
she is. Yes, she is.
She's a tremendous
She's
person.
amazing.
Yeah, she's
Yeah,
an amazing
she's
person.
amazing.
But there was a time when she was born to shop, and she really cared about whose name she wore on her behind, as I like to say.
Yes.
And I wouldn't have wanted. She's my only child. I would not have wanted her to receive all of her inheritance from me at one time. I would have wanted her inheritance from me to be deferred over time. I heard a financial planner recommend once that you ought to give younger children, younger meaning young adults,
Yes.
20s, maybe even 30s, parcel their inheritance out in stages, because you can pretty much count on the first distribution being consumed like the prodigal son consumed his. And we would hope that the beneficiaries would, like the prodigal son, come to their senses, and then they have some inheritance to fall back on.
Yes.
So for people who want to defer distributions to their children, or their children or grandchildren, whoever they want to benefit, may be disabled, there are certain types of trusts, special needs trusts, that can be set up for disabled beneficiaries to protect their needs-based benefits, their Medicaid and SSI, for example. So those are some reasons why setting up a trust can be important, even when there's not a need to minimize the estate taxes. And then certainly the third reason is to avoid probate, which is a very good reason. Probate can be intrusive, it can be expensive.
And it's public.
And it's public. That's the big deal.
Everybody gets to look at your stuff.
Everybody gets to look at. I did a speaking engagement about a month ago when I had a lot of time to talk, and I told the audience how I taught myself to do probate cases. This was back in the 1980s when the local probate court would allow files to be checked out for 5 days. And so when I got, there was an issue in a case that I didn't know how to handle, I would go to a clerk there and say, can you think of some cases where this was going on? And they'd say, yeah, they'd give me a case name. And so I would go pull the file and take it home with me and study the file and figure out how to do what I needed to do in this case. In other words, I could actually take that probate file home with me.
That is so amazing.
Now the local court doesn't allow that anymore, but you still can walk into the court, sit at a table there,
and look
at the file. Yeah.
I don't think most people are aware that that is so public, that the probate process is public information, and the procedures are public as well. And anybody can go down and look at everything the decedent had.
Yes, and what you mean by that, Michelle, is any of the probate assets that the decedent had, because if there are non-probate assets, they are not publicly disclosed in that probate proceeding. And I've had people ask me, so if something in my estate has to be probated after all, does that pull all the other assets in? No, it does not. So for example, life insurance that has beneficiary designations on the policy, that policy is paid out after death according to the beneficiary designations. Likewise, IRAs and annuities, they payable on death or transfer on death accounts. We can actually even do what's called an affidavit for transfer on death now for real estate.
Really?
And in some situations that's really good to do. Now it's generally, that's a very personal recommendation that needs to be made by your lawyer on whether or not the affidavit for transfer on death is appropriate for your estate plan. The public has enough information about that and they want to avoid probate. Our office will get calls and we'll get a request to do, it used to be called a TOD deed now,
Right,
you know.
right.
Well, the nomenclature has been changed, but it still has the same effect.
Okay.
But I generally don't recommend those for, unless death is imminent or when there is more than one beneficiary. Because you see, if mother is dying and mother has two sons who are married, and then mother dies and the two sons inherit that real estate by virtue of the affidavit for transfer on death, then if the sons aren't going to keep the real estate and they're going to sell it, well, their spouses have to join in the sale of that property because the spouses have dower rights. Exactly. So you've really designated 4 people as beneficiaries instead of 2 if they're married.
And hopefully they're married friendly.
They're married, yes. Hopefully they're married friendly and everybody gets along, but they don't always get along. You know,
it does not always work
so
like that.
in that situation, we would more often than not, if the client is really motivated to avoid probate, we'd suggest a revocable living trust.
Okay.
And that's spelled R-E-V-O-C-A-B-L-E, you know,
Yeah.
revocable as opposed to irrevocable, that cannot be changed.
That's very good information. Do you all get much involved in any kind of Medicaid? Because that is the hot topic today, the loss of assets resultant from a spouse or the individual having to go into long-term care.
Yes, yes. I do a significant amount of Medicaid planning or asset protection planning.
Yes, right.
We generally call it Medicaid planning for short because the context in which we're doing it is generally for people who've been diagnosed with some kind of a dementia-related illness or Parkinson's disease or, had a stroke, and they don't have long-term care insurance. And certainly now is the time again
Here we are.
to say, get long-term care insurance. Get it, get it, get it. If you're insurable.
Get it.
Yes, that's all I can say about that. Yes, get long-term care insurance. But many people have chosen to not get long-term care insurance or are not insurable. Perhaps they've been diagnosed with something from childhood that has prevented them from being insurable. And so clients come in and we ask them to fill out that checklist because we need to know income, we need to know assets in order to make recommendations about the Medicaid planning.
I can't underscore enough the necessity of long-term care insurance.
Yes.
I know people just don't believe it's going to happen to them.
Right.
But the statistics are so crisp.
Yes.
69% of people over 65
yes.
are going to have situations that involve long-term care.
Yes.
And again, you can roll the dice, but I share with people that that is not a dice that you want to roll.
No, not at all.
Not at all.
And Michelle, so we may make recommendations with regard to Medicaid planning, and a lot of people have heard enough about trusts that they're hoping they can set up a revocable living trust, and it's like no, because by its nature, if a person has the ability to have access to her or his assets, then they are countable resources for Medicaid purposes, and of course, in a garden variety revocable living trust, one has access to one's resources. So there are some types of irrevocable trusts that will qualify a person for, will put a person in a position to qualify for Medicaid, but protect their assets as well. But you have to have time to do that.
Because isn't there a there's a
5-year look back period, yes.
Right.
Which, in a nutshell, if you need nursing home care and you file a Medicaid application, which is like a small booklet, and you have to disclose everything you own, including whether or not you've made gifts during the last 5 years, asset transfers, putting the property in somebody else's name, any way you call it, you know, it's still an impermissible transfer for Medicaid planning purposes. And so there is a penalty period looking forward that's calculated by dividing the value of the assets transferred by the average monthly cost of nursing home care. So, for example, in the vicinity. So, for example, if $120,000 of assets are transferred, let me use 6,000. I'll make this real simple math, okay?
Yeah, okay.
So 120,000 divided by 6,000 is 20.
20.
So that means that the penalty period would be 20 months. And the problem is that most people, I heard a professional in the long-term care insurance industry say, the time to do planning is not when the house is on fire. And unfortunately, most of the time, the house is on fire when my office gets the phone calls. And so then the advice has to do with what is there anything we can still do? And yes, there are some things that you can still do, especially for a married couple, but there aren't a lot of things.
Right.
There aren't a lot of things, and there's not a lot of hope for protecting a significant amount of the assets at that point.
I'm glad you're talking about this, because Alzheimer disease, that ugly little A word, is epidemic. And I went and heard an amazing doctor who specializes in memory disorders speak on this. And they can live up to 20 years. That's a long time.
Yes, yes.
And whatever assets they had are surely gone, done.
Well, for a single person, to be sure. Now,
Yes.
the asset rules are different for married people. There are some assets that a married couple can keep. For example, in the Medicaid speak, we call the spouse who is in a nursing home the institutionalized spouse, and the spouse who is still able to live at home, the community spouse. And so the home is an exempt asset for the community spouse, for example. And
The car?
The car, one car, regardless of value. I asked a colleague one time, does that include a Lamborghini? And he said yes. And I said, whoa.
Grandma's driving
a
hot car.
yeah. And then there are some of the assets, some of the investments can be retained. The figure is indexed for inflation. It's around $120,000. But say the family, they have $1 million worth of investments. They're going to need to spend down to about that $120,000 figure before the institutionalized spouse will qualify for Medicaid.
That is devastating.
Sure,
That is absolutely, to have spent your entire life accumulating assets so that you will be able to enjoy your retirement years, which is the fall of your life, and to find yourself confronted with this devastating occurrence that is facing so many people daily.
Yes.
And if I may be presumptuous, I would have to say the baby boomer generation, of which I'm a part of, those 10,000 people a day retiring, 78 million, a bunch of people are going to see their assets lost because they failed to do adequate planning. As you said, the house on fire.
Yes. And Michelle, one of the things that you and I both know is that there is certainly a common presumption that long-term care insurance is very expensive. And I ask, even beg some clients, if I feel that I can in a particular situation, please make an informed decision. Talk to a long-term care insurance professional and get the facts, not what you heard at the coffee clutch or bridge club or wherever, church social, but get the facts for yourself based on your health, your age, your insurability, and then make an informed decision. I've actually suggested to some children who have brought mama to the appointment because she really had expected to just own her assets for the rest of her life and then transfer them to her children when she dies, and She really hadn't done long-term care planning. Well, now she's been diagnosed with something that has the potential of dissipating her assets, or maybe not. Maybe she's still healthy, but she's just older, and the children want to know, what can Mama do to protect their inheritance?
Right.
And Mama doesn't have, she's of an age where the long-term care insurance may cost significantly more than it had if she'd gotten it 20 years ago. And I'll suggest that children, if she's still insurable, why don't you pay for it, at least contribute to the cost, since you have vested interest in protecting her assets.
I think that's very prudent advice. Children should, particularly if the policy is under a partnership where the state will exempt those assets.
Yes.
That's significant.
Yes.
And yes, I do think that children should have the opportunity and the privilege of paying for that for their mother if they want to be the benefactors of those monies.
Yes.
These are such odd times, and the things we're talking about are so different.
Yes, and you know, our clients run the gamut. We really don't limit who we accept as clients, except we do like for them to pay us.
Of course.
We do some pro bono work, but we choose those cases, you know.
Right.
But we start teaching, I won't say preaching, although I suppose it could rise, that fervor could rise to that level, teaching people, young couples, about long-term care insurance. I'm remembering a couple, she was a teacher, and so we met during Christmas break after Christmas in 2012, and I pulled out the brochure that I usually give people, and I say, now, I'm not suggesting that you go buy long-term care insurance now, but I'm planting a seed. I want you to know that this exists, and that when you're around age 50, I want you to look into it and consider it. But I was ignorant when I was your age, and my husband died young, and we hadn't done planning, and my job is to help educate you, so you're not ignorant like I was, so that you know.
I think that's such a ministry in and of itself.
Well, that's how I look at it.
I mean, it really is, because so few people have the vantage point that you have, to be able to know what the law is and to be able to make recommendations, knowing what potential outcomes will be. It's hard for people to distance themselves objectively and say, this is going to happen to me. I mean, Nancy, I didn't even think, I can't believe I'm in my 60s. I'm like, what happened here?
I know.
I mean, it's like poof, and here I am. And things happen fast today. They simply do. They're not as crisp as in my younger years.
Yes.
And I don't think I'm alone. I think a lot of people are probably facing those same identical challenges.
I agree.
So, we've talked about the basics for estate planning, that everybody has an estate. Or does everybody have an estate? Who doesn't have an estate?
Well, Michelle, because estate planning includes issues relating to health care decisions, I mean, I don't know anybody who doesn't have, I tell parents, if your kids have a boom box and a car, you know, when they're 18, they have an estate, you know, and we have a little simple estate plan package that we do for young adults.
Really?
We do. And we give them the right of disposition of remains form. Of course, some of them freak out. You know, I'm planning my funeral at age 18, you know? Yes, it happens. The youngest widow who we had in our young widow support group was 19.
Oh my goodness.
Yeah.
Oh my goodness.
So we give them the health care directive forms, and we give them that rotor form, and we do a general power of attorney form when we fix up a little simple will, and then they're on their way, because the three famous cases of the women who needed health care decisions in crisis, and they didn't have the the healthcare directives in place. The last one being Terry Schiavo down in Florida, and then Nancy Cruzan, and the first one, I can't remember, it was so long ago, the seminal case in that area. They were young women. They were young.
And had these
And they
things
did not
happen.
have the appropriate documents in place.
Well, I know the young lady in Florida, to watch that was just heart-wrenching.
Yes.
To see the parents and to see the husband and to see all of this, because that just seemed so improbable. But yet, in fact, these things happen every single day.
Yes, yes, they do. Yeah.
My goodness.
Now, you asked what are some things that are overlooked?
Yes.
And one of the things that my staff and I find is overlooked is the general area, back to probate, that, as I talked about earlier, any lawyer can write a will, but the issue of avoiding probate hasn't necessarily been explored with the client. And so if the client has gotten a trust, then at least in our office, we review trust funding and how those assets get put into the trust so that probate is avoided, or the other goals of the trust are carried out, if it's deferring distributions to beneficiaries, for example. But too often we find for people with more simple estate plans, perhaps they've got a house and a car, their IRA, pension, maybe $100,000 in assets, but they don't have a survivorship deed to their home. We'll do a survivorship deed for a husband and wife. And what our Ohio listeners need to know, now I'm only licensed in Ohio, so I can't speak in other states, the surrounding states, but Ohio does not, emphasis not, have automatic rights to survivorship in real estate for husbands and wives. And so when we meet with clients, we want to see a copy of the deed to see how the property is owned. And if it's not joint tenants with rights to survivorship, and the clients have indicated that avoiding probate is important to them, then we'll do a survivorship deed for them.
Would you, just for our viewers, because you used a legal term that many of them may not know with regard to real estate, and that's the joint tenancy with right of survivorship versus a general warranty deed.
Okay.
Because those are still out.
Well, a general warranty deed can be a survivorship deed or not. What's relevant is how the deed is worded. If the deed says the granting language in the deed is to John and Mary Smith for their joint lives, remainder to the survivor of them. Those 10 magic words make the deed, or the statute, the revised code says words to that effect that indicate survivorship. In other words, when one of them dies, the property is going to automatically pass by operation of law, as it's called, to the survivor without having to go through probate.
Okay.
And if the deed simply says to John and Mary Smith, and those 10 words or words to that effect do not follow their names, then it's not a survivorship deed. And when one of them dies, some kind of probate procedure is going to need to be required to get that property transferred to the survivor.
Now that's important.
Oh, absolutely.
Because, as I understand it, if it's John and Mary Doe, without those wonderful words, and they have children, and John dies.
Without a will.
Without a will.
Yes.
Tell me what happens.
All right. Well, then it depends. What happens depends on whether John and Mary have all those children in common or no.
Oh boy.
Let's say they
oh
don't.
Boy.
Let's say it's let's say it's a blended family.
Okay.
Then the estate, if it's not a blended family, if it's what's a intact family? I don't know what word to use to describe it, but that they share, they have the same children, then all of the assets go to the spouse, according to Ohio law. But if it's a blended family, then the assets have to be divided between the children of the one who died and the surviving spouse.
My goodness.
Yeah.
Not funny.
No, not funny. So that's you know, with reference to your question about what kinds of things are neglected, that can be very, very, and often is neglected, you know, in the process of estate planning. So it's not enough to get a will. How assets are owned needs to be addressed. We review beneficiary designations on assets. I had a case years ago, probably 20 years ago now, where a young man died suddenly of a heart attack, and his widow came to me to handle his estate, and she said, gosh, his ex-wife was listed as the beneficiary of this $35,000 IRA. And I said, not to worry. I felt so smug. Not to worry. Ohio law nullified, just been a law passed, it nullified that beneficiary designation because of their divorce. And so I called the IRA custodian on her behalf and said, now we're going to be submitting this application for the proceeds. The beneficiary listed is his wife, but Ohio law nullified that. I sent her a copy of the law. I about fell off my desk chair a couple weeks later when she called me back, and because she argued with me, the lady on the phone argued with me, you know, we don't know about that, and anyway, she said, our legal team has done its research, and you're right, Ohio law did nullify that beneficiary designation as to the ex-wife, but Ohio law didn't say anything about her relatives, and her father was the contingent beneficiary, and we are going to pay the proceeds to him.
Oh, no.
And they did.
Oh, no.
And this widow who could have used that $35,000, it went to the ex-father-in-law.
The ex-father-in-law.
Yes. Yeah. So that's why when people go to their lawyer, and hopefully it's an estate lawyer, estate planning lawyer, someone who has experience in these areas, that lawyer they'll bring in their insurance policies. They have paperwork showing who their beneficiaries of their IRAs are. If they don't have that paperwork, that should be part of the estate planning process. We tell our clients, create a list showing everything that you own and how you own it and who the beneficiaries are, and then keep that up to date and keep paperwork with regard to the beneficiary designations in your files.
Well, I don't want to diminish the importance of a financial advisory professional, but I tell you, attorneys are essential and critical in the area of counsel with regard to assets.
If they will do it.
If they will do it. If they will do it.
Now, I can tell you when my first husband was diagnosed with a type of lymphoma, and we had a little baby, and I asked David, my first husband, with fear and trepidation, do you mind getting a will? I mean, you know, that's not the time you want to do it, but I needed to do that. So we went to a lawyer. We were in and out of his office in 20 minutes. He asked us what kind of a will we wanted. We said, we don't know. And he said, what, maybe a simple will? Oh, yeah, simple sounds good.
Yeah.
And David was dead 9 months later.
And you with a baby.
Yeah.
And a simple will.
Yeah. And I sure could have used a power of attorney during that time.
I bet you could
Healthcare
have.
directives weren't around, but a power of attorney really would have helped me.
Yes.
So
that is such a testimony, though.
Well, I'm the poster child for how not to do it. I really am. I've lived through a lot of mistakes, and so I want to make some sense out of those mistakes, redeem them, so to speak.
Yes.
And I would say, Michelle, a lot of it wasn't so much mistakes, it's just the ignorance of being young and uninformed.
Well, and you can be older and uninformed as well.
Can.
I mean, youth is truly a journey, but a lot of us have ended this road still very uninformed, or I should say badly informed or misinformed. Any of those things can happen. Well, I have certainly appreciated and enjoyed our time together again, learned some things that we didn't get to touch on before, and I'd like for you to give your phone number again for the benefit of those viewers who would like to call you.
My office is in Kettering, Ohio. The area code is 937-643-2000.
And to all of my viewers today that have had the delightful pleasure and privilege of learning about this very complex field called estate planning, I'm sure that you have enjoyed this time with Nancy Roberson, attorney at law. And again, no matter where you're listening or who you're talking to, please, please identify a specialist in estate planning. It is critical that you ask for their certification and make sure that you're dealing with people. It's kind of like doctors. You have general practitioners and then you have specialists. If you have a kidney condition, you may start with a general practitioner, but you're going to wind up with a urologist who specializes in problems in that area of the body. The same thing with the legal profession. Do not be moved by people's credentialing if it does not cover the area that you need assistance with. I wish you Godspeed today. I hope you've enjoyed the broadcast. And as always, I sign off as Michelle Graves, wishing you only the best, and God bless you so much. You take care. See you next time.